First of all, I am thankful to the organizers for having provided me with this opportunity to be with you today. Though I am almost a stranger to the actual working of the roster system in the Supreme Court, let me share my own little experience of what I have heard and observed. The subject has taken me back to the year I enrolled myself as an advocate. That was the day my family looked at me with awe and amazement. It was because none of them, except my father, had ever seen a courtroom. My resolve to practice law was difficult for them to digest. Knowing none and with no brief, I would sit in some courtroom or the other, listen to the arguing counsel, and come back home, briefless and with empty pockets. But then, miracles do happen. It was a Friday. I saw an elderly lady lawyer getting up, bowing her head, and saying something. Two serious-looking judges raised their heads, looked at her, dismissed, said their lordships. The lady lawyer passed by my seat, red-faced, head jerking, murmuring something inaudible. While she lost her brief, it made my day. I was watching her great performance, and I followed her to her chamber and told her that I wanted to be her junior. And luckily, she took me as her junior. For a long time, I would carry her bulky files, follow her from one courtroom to another, and became immune to the epithets, good or bad, for the benches. However, one thing is clear to me. What was earlier being said in whispered tones in present times is being talked about openly. And it is something called bench fixing. Though with the passage of time, I became a busy lawyer, the bench and its allure became overwhelming. I was selected for higher judicial service and a few years later elevated to the bench. However, somewhere in the back of my mind, the epithet bench fixing kept haunting. And to my surprise and dismay, I realized that though in the High Court, the registry's hands were clipped by the roster system, that system too was not free from rat smell. And that smell emanated principally from the pen of the Chief Justice, who was in charge of roster. None of the so-called service judges was ever assigned important constitutional matters, habeas corpus petitions, or petitions other involving questions of law. All such cases went to judges directly elevated from the bar, as if the judges from the bar were paragon of knowledge. In Narasimha Rao's bribery case, which revolved around the interpretation of Article 105 of the Constitution and involving not only the person who held the position of the Prime Minister, but other equally important persons, showed not only Judge's indefatigable courage, but also his complete grasp over the Constitution and its interpretation. But what is important in the present context is that the author of the judgment was a service judge. Make no mistake, the case was not assigned to him. It landed before him because he happened to be sitting on a criminal roster, and the question with regard to interpretation of Article 105 of the Constitution arose out of that case. And what is the present state of affairs, particularly in Supreme Court? It has taken the Supreme Court more than 5 years to decide electoral bond petitions involving the very existence and fairness of the election process. Chief Justices came and Chief Justices went away, each shying away from taking up the issue head on. To be fair to the then Chief Justice of India, even in the height of emergency, when Srimati Indira Gandhi was reigning supreme, he did not shy away from constituting a bench and taking up the matter of ADM Jabalpur. It is a different matter that its outcome was highly damning to the fundamental rights of the citizen, and it remains an ugly spot on the fair face of the judiciary. One may ask why no urgency was felt or realized by one Chief Justice after the other in the electoral bond cases or other similar matters involving the rights of the citizens. In the interregnum, much water has already flown under the bridge. One general election and many elections to the state legislatures had already taken place in the meanwhile. And imagine, when a judgment like in the electoral bond matters comes protecting the rights of the citizens, they are not only pleasantly surprised, but feel so relieved as to hail and thank the Supreme Court, even when it has only performed its constitutional duty. And when it does that, it neither needs applause nor brickbats. But the fact that such was the reaction shows how much the Supreme Court has lost in terms of credibility in the field of justice delivery system. The Supreme Court is no longer taken as the last word on any such pronouncement. It is already being talked that the government may move the Supreme Court for review, or the State Bank of India and the Election Commission may ask for further time to carry out such directions, or the government may even bring an ordinance to nullify the effect of the judgment. After all, the government did bring an ordinance to reverse the judgment of the Supreme Court in the matter of selection of Election Commission by removing the Chief Justice of India as being part of such selection. Why have things come to such a pass? The government is not entirely to be blamed. Somewhere down the line, the Supreme Court allowed its authority to dilute. Though it is unfortunate, keeping in view the past performance of the Supreme Court, one feels it is the government which still will have the last laugh. Let me take you to the past. The aggrieved citizen was known by the name of Maneka Gandhi. Our Supreme Court said, and I quote, that speedy trial is dynamic and progressive program of legal assistance, an essential ingredient of the right to life and liberty, and flows directly from Article 21 of the Constitution. These are brave words, but lost somewhere in the wilderness of the roster regime. You do not live on words alone. They need a heart, and a heart that flutters. Thousands and thousands are rotting in jails, standing in the corridors of courts of justice, day in and day out, with prayers on their lips, hoping for the rule, bail not jail, to resurrect. But it surfaces only for the chosen few. Siddiqui Kappan, a journalist who was arrested on October 5, 20, got bail after more than 2 years. When he approached the Supreme Court under Article 32 of the Constitution, the then Chief Justice of India remarked that we want to discourage Article 21. More recently, the Supreme Court declined to hear an Article 32 petition involving the arrest of Chief Minister of a state who alleged that he was arrested on no evidence and with the sole aim of destabilizing his duly elected government. The bench observed, "Why have you come directly here?" The observation was made notwithstanding the fact that many a times in the past, Supreme Court has been entertaining Article 32 petitions depending upon the urgency and gravity of the matter. And more importantly, the observation has come notwithstanding the golden words of B.R. Ambedkar, the architect of the Constitution, describing Article 32 as the heart and soul of the Constitution. Is Article 32 be treated as a dead letter? Remember the landmark judgment of the Supreme Court in Hussain Ara Khatun versus State of Bihar. Recollect what the judges said. Let me remind you. They not only felt that there was shocking state of affairs so far as the administration of law and order is concerned, but also that the legal system has lost its credibility. Arun Shourie has beautifully described the present state of judiciary in his remarkably readable book, The Commission for Lost Causes. He calls the judges as lions without roar and lions without throne. The misfortune is that many of them have not only lost their teeth, but have also lost their roar too, leaving the ordinary citizen to the mercy of predators and jackals. What we find today is that while a powerful person gets bail on an experimental basis, men like Umar Khalid are withering away, unwept, unsung, and unheard, and so fed up that coming out of the corridors of the Supreme Court is itself considered a relief. While a journalist spends time in jail for the crime of performing his duty, an old and ailing man, unable to even sip water, is denied basic medical aid and is made to suffer and die behind the bars. What has happened to Article 21? Why those swearing by the Constitution have forgotten cases like Hosnaira, M.H. Hawkshaw, Sunil Batra, and A.K. Roy? What has happened to those brave words in Ratan Singh versus State of Punjab, where the Supreme Court said, if freedom and liberty are to have any meaning in our democratic setup, it is essential that at least these safeguards are not denied. Is our judiciary putting down who deserve to be pushed down and putting up who deserve to be pulled up? Or is it just becoming gilded tom of a failed talent? The question is not who is making them dance. The question is who is dancing and why. While I was penning these lines, I had before me two headlines in the Indian Express. Without a comment, I am reading them out to you, leaving it to you to react. Here is the first one. A bench of Justice B.R. Gavai and Sandeep Mehta observed, where the question of liberty of a person is involved, even a day's delay counts. And here is the second. 24 years after a man dies in police custody, ex-cop sentenced to 10 years jail. How do you reconcile the two? One decries even days delay, and the other tells us of delay of 24 years. Remember those 5 judges of the press conference fame. One of them, a friend from days of our mutual struggle at the bar, is present today. What happened thereafter? Any reform? Any improvement? Let us remember that a driver's competence is not established by his dress or his religious fervor made public, but by making his passengers reach their destination safely. A judge must fall in love with the Constitution before he approaches it. The original is beautiful. Its reach is not limited. It is not the roaster. It is the judge who assigns the cases, and it is the judge who decides the matters. Shakespeare in Julius Caesar writes, his life was gentle, and the elements so mixed in him that nature might stand up and say to all the world, this was a man. Are we today sure of the presence of such a man? If not, surely we need him. Though many today are seen taking a deep breath and agreeing with मीर तकी मीर, इबतदाए इश्क है, रोता है क्या, आगे आगे देख, होता है क्या. Having said all this, I will be unfair to the roster system and to its master by not pointing at least 3 pronounced advantages of the roster system, and which fortunately or unfortunately have already become public, and they are as follows. Number 1, the master of roster can constitute a bench of his own choice and himself preside over it, even in a very personal matter. Number 2, by intelligently making use of that power, he can assure himself, even after his retirement, a cozy job like a seat in the Rajya Sabha or governorship in sub-state. 3, by intelligently using his power, he can equally benefit his very worthy and dearest colleagues too. Thank you so much.